Well, good afternoon, everyone. I think this has all been very exciting so far and quite educational and promises to continue that way with our last panel. First, we'll be hearing from Manian, professor of law at the University of San Francisco. And she's going to be talking about the consequences of abortion restrictions for women's health care. Then Lynne Marie Kohm, the John Brown McCarty Professor of Family Law at Regent University. Roe's effect on family law will be her topic. Then we'll have a joint presentation from Robin Wilson, recently of our faculty here at the law school, and now Roger and Stevie Jocelyn, Professor of Law at the University of Illinois, and Ryan Hrobak, who is a JD candidate here at W&L 2014, is that right?
Sure.
I didn't. Okay, they are going to discuss emergency contraceptives or abortion-inducing drugs, empowering women to decide for themselves. And then James Mann, also of Washington and Lee, here in our philosophy department, in the undergraduate, what we say is across the ravine. But he has trekked over here to talk to us about innocent burdens on Judith Jarvis Thompson's A Defense of Abortion. So, looking forward to all those presentations. Thank you.
Well, I want to join in thanking the organizers of this fabulous conference. I really appreciate being invited here to speak. I have been thinking recently about abortion and healthcare and the links between the two. And in this talk, I want to challenge the assumption that abortion care can be segregated, isolated from women's medical care more broadly, and targeted for special restrictions without any effects on women's health more widely. Policymakers and the public have failed to understand the interconnectedness of abortion with other aspects of women's medical care. In fact, existing abortion restrictions harm women's health, even for women not actively seeking abortion care. But these impacts remain obscure. Focusing the public's attention on the broader effects of abortion restrictions on women's health could help make visible the links between abortion and health care, and furthermore, repositioning the law to recognize abortion care as an integral part of the continuum of women's medical needs is critical to protecting women's health. Part of the popularity of anti-abortion measures rests on the faulty belief that those laws affect only the bad women who seek abortions. This belief relies on the false assumption that abortion can be isolated from other aspects of women's health care. However, as a matter of medical practice, abortion can't be segregated in this way. So I'll talk briefly about how existing restrictions targeted at abortion have spillover effects on other related areas of women's health care, including miscarriage management, prenatal care, and other pregnancy-related care, such as the treatment of ectopic pregnancies. So the first story I'm going to tell you relates to the federal partial birth abortion ban upheld by the U.S. Supreme Court in Gonzalez versus Carhart. This law illustrates how legislation aimed at abortion impede medical care for women more generally. The federal ban purports to prohibit one type of abortion procedure called partial birth abortion by its opponents, but known medically as intact D&E. The discussion of the law during the years of litigation gave the impression that a ban on intact D&E would only affect a small number of women seeking abortions later in their pregnancy. Yet physicians who do not routinely provide abortion care have nonetheless been impacted by this law. Lori Friedman, a leading medical sociologist, related this story of one physician's attempt to care for a patient who was suffering a miscarriage in her second trimester. She quotes directly from the physician, so I'm going to read a quote from the physician as well, and this was told anonymously. So this is Dr. B. The patient was kind of in the process of delivering, but it wasn't coming fast enough, and she's trying to hemorrhage to death. So I took her to the OR so I could get her to quit hemorrhaging. Well, you know, the whole thing about the partial birth abortion. And it's just like it would have made perfect sense to do that banned procedure, but I didn't. primarily because I was worried that all these, the techs and circulating nurses in the OR are going to think, oh, Dr. B is a baby killer, and she just did a partial birth abortion, and doesn't everybody know that's illegal? Now, in fact, technically, this situation would not fall within the scope of the federal ban because the physician did not begin treatment with the intent of performing an intact D&E. She began with the intent of managing the miscarriage. But nevertheless, regardless of the technicalities of the law's effect has been to create a system in which doctors feel circumscribed in the exercise of their medical judgment. The law has become its own panopticon, a perpetual surveillance system that inhibits not just abortion care, but the care of pregnant women suffering from miscarriages. We don't know how often circumstances like these arise and at what risk to miscarrying patients, because these stories are rarely told. But these laws have effects in the ER, in the OR, that we might not be aware of. The next area I'll talk about is the information control. The regulation of information surrounding abortion care has spillover effects on prenatal care. So, for example, on the same day that Oklahoma passed legislation mandating that abortion patients undergo a forced ultrasound, it also passed a law protecting physicians who fail to disclose fetal anomalies from tort liability. Normally, that would be negligence, a failure to disclose material information, and a doctor could be sued. In this particular situation, they're precluded from being subject to that normal tort liability. In other words, Oklahoma law forces unwanted information on some pregnant patients while at the same time empowering physicians to conceal wanted information from others. Proponents of this legislation assert that laws of this sort are only anti-abortion measures, thwarting women who would seek an abortion if they knew of a fetal anomaly. In reality, laws that deny information in the context of prenatal care affect not only those women who may consider terminating a pregnancy, but also those who would not choose an abortion but need the information to plan for their families. Dr. Rena Anderson's story illustrates this point. Dr. Anderson worked in private practice after her OBGYN residency. Her practice allowed her to perform second trimester abortions for patients with fetal anomalies. Unfortunately, she found herself faced with making the same difficult decision as her patients when during her second trimester of pregnancy, her doctor discovered a fatal diagnosis. She initially decided to terminate the pregnancy since she had 4 months left and was told that her fetus would likely die in utero. Then she made a decision that surprised even her. So again, I'm going to quote from the doctor here. This is Dr. Anderson. She says, "And then I changed my mind. For me, there was I don't really know, it was kind of the inner voice that said, don't do it. Maybe you might get some time with her or something." And we did. We got 10 days with her. They had said with one of the birth defects that she had, only about 3% make it to term. So we felt pretty lucky from that respect. Now, in telling this story, Dr. Anderson emphasized that people can be pro-choice and still choose other options, as she did. But obviously, that choice is only available if patients have the information to make a decision. Without information, women and their families who would choose to keep the pregnancy, as Dr. Anderson did, will not have the opportunity to prepare emotionally for an infant's serious illness or death, and thus, as in her case, appreciate the time they might have, or to arrange appropriate care, such as perinatal hospice, or to take financial steps to provide for a disabled child. Furthermore, certain fetal conditions require special care in utero. Early knowledge, decision-making, and medical intervention can be essential to a positive outcome. And in addition, in some cases, testing can reveal information about fetal characteristics that could threaten the mother's health. Thus, this assertively anti-abortion law impacts far more than simply abortion decisions. It affects lots of decisions that can happen in the context of prenatal care. Third area I look at is conscience legislation and sectarian hospitals. Conscience legislation shields institutional and individual actors from liability for their refusal to provide care, even if it contravenes accepted medical standards. Although claiming to restrict only abortion provision, the policies of some privately owned sectarian hospitals, ensured protection by conscience legislation, impede physicians' ability to provide appropriate care for pregnant women. In particular, pregnant women with emergent conditions such as miscarriage or an ectopic pregnancy face risks to their health due to anti-abortion policies. Now, obviously, there's variance at both the institutional and individual level in execution of doctrines at sectarian hospitals. So I'm not painting with too broad a brush here, but in some cases, anti-abortion policies have resulted in miscarrying patients receiving delayed care, patients being transported to a non-sectarian hospital for treatment while unstable, and in one recent case in Ireland, death. This case was mentioned earlier. Savita Halappanavar died from a miscarriage at 17 weeks pregnancy in Ireland. There was a government inquiry into her death, and it was found that one key causal factor was the law, that legislative factors affected medical considerations, and that this resulted in a failure to offer all management options to a patient experiencing inevitable miscarriage. Now, this received a lot of press, a lot of attention in the international news, and you may think this could not happen here, but stories told by physicians working in sectarian hospitals in the U.S. have demonstrated the negative effects of hospital policies on pregnant patients seeking care. A number of physicians employed at these hospitals have even confessed to subterfuge in the aim of protecting their patients' health. In one case, Dr. Brian Smits, a perinatologist, reported resigning his position at a Catholic hospital rather than continue to be subject to ethics committee decisions that harmed his patients. Dr. Smits described the situation that instigated his resignation and his surreptitious violation of protocol in order to save his patient's life. So one more quote from Dr. here. This is Dr. Smits. "I'll never forget this. It was awful. I had one of my partners accept this patient at 19 weeks. The pregnancy was in the vagina. It was over. I'm on call when she gets septic, and she's septic to the point that I'm trying to keep her blood pressure up, and I have her on a cooling blanket because she's 106 degrees. And I needed to get everything out of the uterus. So I put the ultrasound machine on, and there was still a heartbeat, and the ethics committee wouldn't let me because there was still a heartbeat. This woman is dying before our eyes." So he goes on to explain what he did. "I went in to examine her, and I was able to find the umbilical cord through the membranes and just snapped the umbilical cord, and so that I could put the ultrasound. Oh, look, no heartbeat, let's go. She was so sick, she was in the intensive care unit for about 10 days and very nearly died. Her bleeding was so bad that the sclera, the white of her eyes, were red, filled with blood. And I said, I just can't do this. This is not worth it to me. That's why I left." Now, Dr. Smits knew that his hospital prohibited abortion care, but he had assumed that this prohibition would only affect his ability to offer abortion care to patients, say, with medical contraindications who would be seeking it, which he could readily refer to outside clinics. He had not expected a disjuncture between what he considered to be the standard of care in miscarriage management and what was acceptable to his hospital's ethics committee. Similar deviations from standards of medical care may also occur in the context of ectopic pregnancies. Given the market share of some sectarian hospitals and their dominance in some regions, these policies affect more than a population that believes in religious doctrine on abortion. Although patients may be aware that they can't obtain abortion care at sectarian hospitals, few prenatal patients conceive of themselves as potential abortion patients. The last area I'm going to look at very briefly is medication abortion. And similar to concerns about treatment at sectarian hospitals, state laws restricting access to medication abortion may impede appropriate care for ectopic pregnancies. For the sake of time, I'm not going to go into this too much detail, but in a nutshell, the FDA approved medication abortion, termination of pregnancy by drugs rather than surgery, in 2000. All the data we have on it is that medication abortion is very effective and safe early in pregnancy. Alternative regimens to the FDA protocol that was approved in 2000 have become the accepted standard of care in medication abortion. To understand this, it's important to understand standard practice in American medicine. It's standard practice in American medicine to use off-label or evidence-based regimens. The FDA authorizes evidence-based or off-label regimens. It's a widespread practice by physicians in every medical specialty, far outside of abortion care. No other state laws prohibit off-label uses in any medical specialty, not even for children. The only exception I could find was for anabolic steroids, which were abused as performance-enhancing drugs. Despite all this, Oklahoma and several other states have enacted legislation prohibiting off-label or evidence-based uses for abortion-inducing drugs. As the Oklahoma Supreme Court recently found, Oklahoma's legislation was so broadly worded that it banned not only medication abortion in its entirety, but also the safest method of treatment for ectopic pregnancy. So the statute in particular states that it prohibits the off-label use of, quote, any abortion-inducing drug, which the statute defines to include methotrexate. And then contrary to the statute's claim that abortion medication, quote, does not treat ectopic pregnancies, but rather is contraindicated in ectopic pregnancies, the well-established standard of care for treatment of early ectopic pregnancy is the off-label use of methotrexate. It's been used for years to treat ectopic pregnancy. The FDA label has never been changed, and that happens all the time. So in sum, this case, once again, just illustrates how laws targeted at abortion affect other related areas of women's medical care. And these stories belie the claim that abortion care can be isolated from women's health care as a whole. Laws aimed at curtailing abortion have ripple effects that potentially place any pregnant woman's health at risk, as any pregnant woman could be a potential abortion patient. So I'll conclude here by linking back to Roe versus Wade. One oft-heard criticism of Roe, as we've heard here, is that it overemphasized abortion as a medical decision. It's a compelling critique. But now we've shifted to the opposite extreme, where abortion is hardly considered medical care at all. In Gonzalez versus Carhart, the Supreme Court described the abortion decision as purely political in nature, to be left to legislatures to decide, rather to patients and their physicians, and one that is made as a matter of convenience. But abortion is both a social and a medical issue, and as a practical matter, we can't isolate abortion from the remainder of women's health care. Many types of abortion restrictions have unintended consequences which impede the provision of basic health care for women, and surfacing these spillover effects could help decision makers better see and understand the links between abortion and women's health care. Laws attacking abortion inevitably have wider consequences for women's health. Thank you very much.
Hello. Thank you to Washington Lee board and staff of the Law Review. You guys have done an awesome job. Thank you, Dean Calhoun, for putting together all these people who are so diverse, and yet we're all getting along and having a good time at it. And it's really welcoming to see all the students here. Welcome, you guys. Glad you're here. Family law deals with the regulation of the most sensitive relationships in our lives, those between wives and husbands, those between parents and children, and those between people that share a household. Family law regulates entry into these status relationships, such as marriage, and the ways to get out of them, such as divorce. But generally, domestic relations law deals with two distinct and opposite competing liberty interests, both of which are paramount to the state. The first one is the preservation of the family and family privacy, and the second one is the protection of individual members in the family. The competition between these two positions has been highlighted because of Roe, and family law has experienced some dramatic changes in the 40 years since this landmark decision. I discuss these in three major areas of change. The first one is changes to the parent-child relationship. The second is changes in marriage or to the spousal relationship. And the third is changes to sexuality, romance, and the family generally. This expansion and contraction of family law as a whole has really included seismic shifts in fundamental foundations of familial relations from what were previously understood, particularly between spouses, between parents and kids, and between men and women. And while those changes are not necessarily a direct result of Roe, the decision's influence is undeniable. So let's talk about the first one, Roe's effects on the parent-child relationship. Historic recognition of broad parental authority to raise children made the family the basic social, economic, and political unit. When Roe legalized the right to abortion, these notions were changed, revising the parent-child relationship in completely new ways when abortion was involved as a choice a child can make. These legal developments from Roe that expanded a child's privacy and liberty interest became the genesis of expanded notions of the mature minor doctrine. And generally within family law, states have deferred to parents as the legal authority, the legal protectors, to help their kids make decisions regarding the medical treatment of their children. Some jurisdictions even carved out an area of law that permits minors to statutorily determine their own medical treatment if the minor is mature enough. And we heard a little bit about this yesterday. When the Supreme Court determined in Roe that as a matter of constitutional law, a minor must be permitted to make her own decision whether to terminate her pregnancy, states went to work to protect that parent-child relationship and for the child's best interest to include parental involvement in a child's abortion decision. And they have manifested as laws in every single jurisdiction. Evidence of that is right here. These are all the states that have made parental consent laws. These are all the states that have made parental notification laws, and these are all the states that have done both. Roe changed the parent-child relationship permanently, and this is evidence of it. What I don't have time to discuss in this area of the parent-child relationship are all these other aspects of the parent-child relationship that have been altered with laws since Roe. One is safe haven laws, another one is fetal homicide laws, another one is wrongful birth laws, wrongful tort action, wrongful life tort actions. Child support has dramatically been changed. I go into that a lot in the article. And then the general change of the value of a child. You have to kind of ask yourself, what does it mean to family law when the law has endorsed a parents terminating the life of their own child? So this has been dramatic. Roe has affected the parent-child relationship, and it's really pretty undeniable. So let's look at the next area, Roe's effect on marriage and the spousal relationship. Well, Roe disallowed many state and federal protections for marriage in its holding of Casey. And I agree with Priscilla when she said yesterday that Casey is really the law of the land on abortion. But Casey wouldn't be possible without Roe. The marital relationship was really altered by the court when it said that that it was an undue burden for a wife to mention to her husband she was having an abortion. Rather than promoting marital harmony, the court pushed a wedge between that husband and wife relationship. They raised the issue of disharmony in the marital relationship as justification for seeking an abortion, as a reason that she would be unable to discuss the matter with her husband. But that also effectively thwarted any husband to be able to communicate with his wife on the matter of the unborn child of their marriage. So that autonomy set out in Roe really created this spousal distancing in Casey. Spousal communication, which has been historically important to the court, was forever altered by this decision. Lack of communication, as some of us know, is often cited as a primary source for marital breakdown and subsequent dissolution. While following the privacy rationale for contraception in Griswold v. Connecticut, Roe followed that thinking with a further separation of marriage and parenthood. What role Roe has had in the proliferation of divorce, however, is a more complex matter. I look at the proliferation of no-fault divorce laws, which provided for unilateral action occurring largely sometime after 1972 in most jurisdictions, chronologically correlating to Roe. But the increase of divorce rates among American populations generally is thought to be more connected to the no-fault divorce revolution, when the American divorce rate more than doubled. But a reasonable inference could be made that disagreements between husbands and wives as to whether to access the right to an abortion could be either a part or a whole reason for some divorces. But a causal connection cannot be clearly established. Though abortion availability without spousal discussion may not be a direct cause of increased divorce rates, a stronger moral argument can be made regarding the individual liberty interests common to both opportunities of abortion and divorce. The autonomy fostered by abortion rights and privacy and choice to one marriage partner creates a wedge in the notion of marital oneness. That separation serves to weaken the marital bond. Roe opened up the options that altered how couples deal with the choice to become parents. They don't have to face abortion together. The result is that parental choice to abort a child rests with one party, something not really conducive to marital unity. This expands the wedge into marital oneness, and you combine that with the unilateral choice to dissolve a marriage, and abortion has the potential to severely weaken the moral fiber of marriage and increase the possibility of divorce. What I don't have time to discuss are other aspects of the husband-wife relationship, namely the intimacy and procreation separation that occurred with Roe, the correlations between abortion and increased cohabitation, and then the connections with marriage, deconstruction, and expansion. I go into all these in my paper. So let's talk about the third area, the thing that I think is the most interesting of all, Roe's effects on sexuality, romance, and the family generally. Roe has brought dramatic changes to relationships between men and women. Sexuality and privacy notions in family law have been expanded and modified in many ways because of the constitutional privacy that was developed in Roe. Somewhat surprisingly, some gender disparity in sexual freedom has arisen as a result of the jurisprudential progression of this privacy. The result has been an increase in the casualness of sex, separating sexuality from responsibility often, resulting in harm to women, harm to men, and harm to their relationships. Women's rights, though thought by many to be dependent on reproductive choice, I argue have been limited by Roe. Let me try to explain that. The availability of abortion has led to a more casual sexual culture, as abortion as a method of birth control has eliminated a potential natural consequence of premarital sex. In her book, Sex and the Soul, Donna Freitas discusses her empirical research on the lives of college women. She says, the problem was that the hookup culture promoted reckless, unthinking attitudes and expectations about sex, divorcing it from their larger value commitments. She notes that college women she interviewed were weary, fatigued by their sexual experiences. She says, after a few years of living in this environment, they felt exhausted, spent, emptied by the pressure to participate in encounters that left them unfulfilled. And she was genuinely surprised by her findings. Let me read you what she wrote. She says, at first, I was taken aback by student stories that many of them, especially the women, endured regularly. We are ostensibly living in the era of feminism and post-sexual revolution. Weren't my students supposed to be beneficiaries of those movements, empowered and in control of their sexuality? I was even more surprised to learn exactly how powerless they felt to change this culture that made them so unhappy. So, because of an abortion right, sexual intercourse and the choice to abort in the event of pregnancy may be becoming more presumed. Clark Forsythe, in his book, and it's great to have him here, his book is called Abuse of Discretion, and there he argues that Roe has not solved the problems that women face still. The availability of abortion has not reduced spousal abuse. It has not reduced the feminization of poverty. It has not provided better job opportunities for women. Rather, the paradigm of liberty and control has essentially magnified the power of uncommitted men, leveraging male influence over women and damaging male-female relationships. Worse yet, abortion enhanced by reproductive technology has unwittingly provided a way for women to annihilate the future of our own gender in rampant gendercide, which is occurring in nations around the world. Furthermore, women are compromised in our relationships with men by acquiescence to arguments made by a lover based on the availability of abortion. Because a woman can get an abortion, it could be assumed by her lover that she will do so to keep the relationship free of responsibility. The result is that Roe has been a factor in the breakdown of romance and has really harmed women's choices. These effects, I argue, have harmed men as well. And now there we go. I argue they harm men as well, particularly in the loss of the opportunity to take responsibility for the relationship, for parenting, which I go into more deeply in the article. Changes to family law generally brought about by Roe have also affected the family as an institution. The combination of legal changes from Roe in the parent-child relationship, the spousal relationship, sexual relationships between men and women, in law and culture have led to a more individual-focused legal environment in a family law context. George Mason family law professor Helen Alvare has written, quote, our American culture is experiencing later marriages, historically low birth rates, high abortion rates, 400,000 frozen embryos in storage, and record creation of more or less temporary sexual unions, resulting in high numbers of children at risk for the difficulties that arise in one-parent homes. Roe's effect on laws concerning contraception and abortion, and particularly regarding minors' access to contraception and abortion, have clearly sent messages about the role of sex in the lives of adolescents, as well as in the lives of adults, and has assisted in moving family law toward a set of protections of individual interests, rather than a code that protects and strengthens families. All of this has had an impact on family strength, weakening the unit and the institution generally. Now, what I don't have time to discuss are all these numerous equal protection problems that I came across in the literature. I have tons more on the hookup culture, and I don't have time to discuss this important piece of the divorce puzzle, the connection between premarital sex and cohabitation. But I do that in the article. Roe has had a profound effect on the family, and it has had a profound effect on family law. It has altered the parent-child relationship, the spousal relationship. Its ideology is connected or correlated to devalued marriage, increased divorce, increased cohabitation, and a culture of casual sexuality that has really harmed women. It has changed relationships between men and women, and it has led to unique harms to both of them. In the end, 40 years after Roe, alterations to family law include an expansion of increasing individuality and a decreasing sense of community in the family, a contracting sense of that community, even between members, family members related by blood or consanguinity. 40 years of some of the most profound changes to family law have occurred since Roe, and a significant amount of those are manifestly effects of Roe. Thank you very much.
So you are about to see a true W&L presentation in this sense. We have Cameron Flynn to thank for the slick presentation that you'll see, Amy Bianchini for hearing it ad nauseum, and most important, Ryan Hrobak, my former research assistant and now co-author, for doing all the work. So, and I'm just going to be the front man for a few minutes. So we are going to talk about a new front in the abortion debate, the controversy surrounding abortion-inducing drugs and devices like Plan B and Ella, the emergency contraceptives, I'll call them ECs, but also older contraceptives, the same charge is made, like IUDs. Now, this controversy clearly was stirred to new heights by the Obama administration's contraceptive coverage mandate. And you know that regulations implementing the 2010 healthcare reform law require all plans, whether they are public or private, whether they are commercial or self-insured, to cover all FDA-approved contraceptives and devices. And religious objectors suing over this mandate have said that basically this is, and you're seeing one of the complaints, tantamount to providing abortion on demand. And the White House counters very simply on its blog that these things just don't cause abortion. And that tees up a factual claim that we've heard a lot about today and we'll hear a little bit more about. Now, the reporting about abortion-inducing drugs or abortion-causing drugs actually spikes, as you can see in this nifty little research by Ryan Hrobak, after the 2010 ACA. And you can see that it really brings this fully into the American consciousness. But that is hardly unique to the mandate. Long before the mandate, we saw religious objectors like this person, Toni Lemley, who was in litigation with St. Tammany's Parish Hospital. She worked actually at a wellness clinic as the immunization coordinator. And that wellness center began offering family planning clinics on Thursdays and Fridays. And when the hospital says to Lemley, hey, you're going to have to administer EC, you can see that she is freaked out by that, vigorously objects, and says that she can't do it. The hospital gives her these workaround alternatives, like, hey, you could work from Monday to Wednesday. You can imagine that was not acceptable to her. And so she ultimately sues under Louisiana's employment non-discrimination statute, as well as a non-discrimination provision in the hospital's own contract with the state. The Louisiana Supreme Court ultimately allows that suit to go forward. But in the meantime, the Louisiana legislature has her back and says to people like Lemley, you can step off from a procedure that you have religious or moral objections to, but it cannot come at the expense of patient access. Now, that is what I have called a qualified hardship accommodation. Maya and I are on the same place on this. In other words, that your religious conviction should not imperil access. On the other hand, the claims about access, especially ones that don't have a factual basis, should not keep religious objectors from being able to step off. And we can have both usually when you take sort of creative steps ex ante to preserve both access and religious liberty. Now, many of my girlfriends and different people I've talked to about this really see that Lemley's objection as a kind of zygote worship. That's her word. Basically zygote worship that would be engaged in or thought of only by a handful of crazies or wingnuts. And in part, I think this resistance rests on the notion that nobody could possibly believe that a pregnancy exists this early, so that drugs that work in the hours or the days after unprotected sex cannot be an abortion by definition. Now, some groups like Guttmacher, which I think actually is really quite good, but on this I'm not so sure because they make a stronger claim. They say that the medical profession uniformly measures pregnancy from implantation, and that is just not true. Some medical authorities measure pregnancy from fertilization. Some measure it from zygotic transcription. Some from implantation. My favorite is a positive pregnancy test. In other words, you ain't pregnant until the test says so. And then the last, among all other credible options, is the first heartbeat. Now, that's really late, right, as we saw in our earlier presentation today. Okay. Now, many medical professionals themselves are split on what the start of pregnancy is. So, for example, 57% of U.S. OBGYNs said that pregnancy begins at, quote, conception in one study, by which the study authors believed that they meant fertilization. Now, it wasn't a well-done study, but 28% said that they thought that it started with implantation. 16% of OBGYNs did not know, which seems odd. But in any event, and each of these people brought preconceived notions, that pun is intended, preconceived notions to this idea. The single strongest indicator of what they would believe was their own views on abortion and the importance of religion in their lives. Now, clearly, though, the two leading contenders for the beginning of pregnancy are implantation and fertilization. There's just no doubt across these medical authorities. And obviously, how one defines pregnancy determines whether a given drug or device may induce an abortion in that person's view. Now, like medical professionals, women themselves are split on what it means personally for them if a drug acts at a certain juncture. So, for example, one study of females who were 18 to 50 who were seen in Utah and Oklahoma family planning and OBGYN clinics were asked, would they use an emergency contraceptive that acts after fertilization? And 53% said no. 74% said they would not use it if it acted after implantation. And when they were asked if they would stop using their own specific birth control method, now I've forgotten, 44% said they would stop. 69% said they would stop if they were told that there was a remote possibility that it worked after implantation. Now, like the claims about zygote worship, some groups want to say that EC never acts after fertilization, period, full stop. You probably saw that reported in the New York Times last summer. And note that in this quote, they lumped together Plan B and Ella. I'm going to argue that that's a mistake in just a moment, that they operate in very significantly different ways. But the first thing that I want to say is that religious objectors did not make up concerns about the fact that Ella might act after fertilization. They read it right off the label for both of these drugs, as you can see here, which say that they sometimes act to prevent attachment or implantation of the fertilized egg. Now, we had a little reference this morning to a biology lesson, so this is more than you bargained for, but here is the biology lesson. The early embryo has a narrow window for successful implantation. It's approximately 4 days. Now, we can agree that if a drug acts here to prevent the release of an egg, it prevents fertilization, and it acts just like any other ordinary contraceptive. But we can also agree that if a drug acts here, way late, to slough off a fertilized implanted egg, that would be an abortion under almost every definition of pregnancy, as well as our government's own definition of abortifacient since 1975. Now, importantly, by the way, no mandated drug is presently understood to act that way, and any drug that is mandated, like that is not mandated, no mandated drug is presently understood to act that way, and drugs that do are not mandated. So, biggest question is what happens if a drug acts in the middle, this area in the red, or what is called a contragestive effect. Now, my reading of the literature basically confirms partly what we heard this morning, which is that Plan B's mechanism of action is as a contraceptive. In other words, since its approval in 1999, the only way Plan B has been demonstrated to operate is as a contraceptive, meaning it impedes the sperm, it actually impedes the release of the egg. Nothing meets nothing. It is a contraceptive. It prevents fertilization. But the evidence about Ella, which was approved in 2010, is shaping up very differently. Plan B is effective for up to 72 hours after unprotected sex. You probably know Ella works over 120 hours and is much more effective in preventing expected pregnancy than Plan B. And the question is why? Now, some peer-reviewed articles, legitimate medical authorities, believe that Ella's enhanced increased effectiveness may be because of a contragestive effect, i.e. an effect after fertilization. Some pharmacotherapy experts posit that Ella's enhanced effectiveness over Plan B stems not just from contragestive effects, but in fact acting at the moment of implantation, in other words, causing the immunorejection of the embryo attempting to implant. Now, in this view, Ella may work sometimes for some women to derail the process of implantation itself, but that is a big and emerging factual if. We don't know. Now, as with Plan B, evidence of Ella's precise mechanisms of action may become clearer as studies accumulate over a series of years. But for now, it seems that Ella may sometimes function not just to keep the sperm and the egg apart, which is what their website says, but in fact to act after that moment, right, in a contragestive effect. And members of the FDA panel that approved Plan B for sale over the counter, like Dr. Charles Lockwood, were concerned that women might inadvertently violate their own moral and religious beliefs, which is why this shows up on the FDA label. And family practitioners like Dr. Wallace believe that doctors should have an open and honest conversation with patients about how these drugs and devices may work so that women can decide for themselves, and Ryan has a lot more to say about that.
Right, so Robin just brought up this bit about these open and honest conversations. And this is precisely what the law aims to foster through the doctrine of informed consent, so that women can participate meaningfully in sort of medical procedures and medical decisions. But for the large part of American medical history, this just was not the case. Patients and doctors didn't really talk and didn't disclose information, and this is largely due to two reasons. One is just the problem of paternalism, that the doctor knows best and just shut up woman, right? The second thing is that claims against doctors from patients sounded in the common law tort of battery, so that if a doctor did a procedure on a patient and he had some sort of simple consent that he could raise as a defense, that's all he needed. So, for example, here's how bad it actually was. In a case decided as late as 1955 in Nevada, a woman named Ruth Kohm went to a doctor for a problem that she was having with her right breast. And he sort of suspected that it was breast cancer and indicated that it might need to be removed. And she said, absolutely not. And he said, all right, I won't remove it. That's fine. I'm just going to run a test. So he has her sign this consent form to perform a mastectomy, a hemorrhoidectomy, and whatever else she needs to have performed. But the problem is he actually went ahead and removed the breast. She didn't know what a mastectomy was. She verified with him after signing the consent that he wasn't going to take the breast off, but he takes it off, so she sues. The Nevada trial court actually granted the defendant doctor's motion to dismiss because she signed this form. That's sort of a problem, but we've gotten away from that Neanderthal view. And as a result of various judicial decisions and legislative enactments, the vast majority of states now impose disclosure duties on doctors to ensure that patients can give informed consent to medical procedures and have autonomy to decide what happens to their bodies. Broadly speaking, in American law, there are two general standards of disclosure. The first standard is the professional standard. And the basic thrust of this is that physicians must disclose only that information which a reasonable medical practitioner would disclose in the same or similar circumstances. So the focus here is on the doctor, or on sort of the legal construct of the reasonable medical practitioner. And you look to sort of the habits of the medical profession, customs, and that sort of thing. The second standard is called the material risk standard. It's also known as the lay standard or the patient-focused standard. Under this standard, physicians have to disclose all information about a proposed treatment that a reasonable person in the patient's circumstances would find material to a decision to forego or undertake treatment. And sort of both standards are good and bad in a lot of different ways. On the one hand, because the professional standard developed first, and because medical malpractice cases of different varieties employ a professional standard, the law is familiar with this. People sort of get it. Secondly, the professional standard permits the medical profession some degree of autonomy and freedom in deciding what they have to disclose. And third, doctors understand what they have to do with this standard because they know what other doctors do. The drawbacks, however, are that number one, with cutting edge or new technology, there is no standard, right? There's no custom, there's no habit, so we don't know what needs to be disclosed. Secondly, the professional standard may actually not require enough disclosure on the part of the doctor for the woman to participate in the decision. So the material risk standard involved to remedy this. But with this increased autonomy for women in being able to participate, physician burden increases because they have to disclose more information and they have to figure out, what do women want to know? But I guess the key thing here is, what does this mean for emergency contraceptives, right? And I think sort of two key cases are helpful in determining what this would mean. So in 2007, the Supreme Court of New Jersey decided a case called Acuna v. Turkish. It involved an informed consent claim in the context of an abortion. The patient sued the doctor on the ground that he did not inform her of the scientific and medical fact that her 6 to 8-week-old embryo was a complete, separate, unique, and irreplaceable human being, and that an abortion would result in killing an existing human being. So New Jersey applies material risk. They actually find for the doctor, they specifically find that the doctor did not have to use those words. But what they did indicate is that you have to disclose gestational stage. So you have to talk about where are we in gestation, and how is that going to impact wherever sort of the embryo or the fetus is at whatever stage. And then in another case decided by an Illinois appellate court in 2011, a patient sued a doctor for an informed consent claim on the ground that he did not inform her that an abortion procedure would terminate the life of a second patient, a living human being, as a matter of biological fact. The professional standard was applied, and the exact same result was reached, that you don't have to say those words, but you have to disclose gestational stage. And so just like gestational stage matters in those cases, so too with emergency contraception. And the FDA committees recognize this in their labeling of these drugs. And this brings us back to Robin's discussion of the legitimate, reasonable scientific authorities on how these drugs work. So I think we can say that in 14 years of Plan B, it might be time to revise the label, right? Get rid of this post-fertilization effect. It seems to only act pre-fertilization. But with Ella, we just don't have that understanding yet. So doctors should be discussing these uncertainties with their patients so that patients can act on their own first principles. Thank you.
Switch it off. That's the screen Okay. Sorry, I make it a rule. In Hollywood, they say never work with an animal or a child. I never work with a PowerPoint above me. So I want to thank the organizers for having me here. I am the interloper from the philosophy department. And however, I'm also the interloper from Ireland, which has been mentioned quite a bit. So I do come from the country in which there is no abortion whatsoever. And that's been of interest to me as I've heard people refer to Ireland in this way. It's not a source of pride for me on that matter. And my family has been involved in various attempts to inform the government and make legislative changes in Ireland on the subject of abortion. That's why I became interested in the topic originally. But today, I'm going to speak purely as a philosopher about a philosophical argument. And I'm going to justify this by saying that I think over the past 2 days some arguments have been made that I would count as philosophical or moral arguments concerning the impermissibility of abortion. So I'm here to counter some of those arguments with what I take to be still the most famous argument ever given by a moral philosopher, which defends abortion. So Judith Jarvis Thomson in 1971 wrote her article, A Defense of Abortion, and it's the most famous article ever written on abortion, and it's arguably the most anthologized article in applied ethics of all time. Before her article in 71, the debate over abortion, at least in philosophy, was largely a debate over the moral status of the fetus. Was the fetus a person, endowed with all of the moral rights that persons have, or not? It was assumed that if the fetus had the same moral rights as you or I, then abortion was impermissible. Thompson's article changed the debate because it argued that even if a fetus was a person with all of the same moral rights as you and I, then abortion was still permissible. I'm tempted to say this conference is called, Roe after 40, but I'm thinking this is 42 years since this has been made. So this is 40 years since Thompson has argued that even if the fetus is a person with all the same rights, then abortion is permissible. So clearly this argument has yet to have an impact in the way that it, I think, could have. Okay, so what is the argument that Thompson is giving? I'm going to summarize the argument before referring to the article and say this. Imagine that you are pregnant as a result of rape, and assume that the fetus is an innocent person with all of the same rights as you or I. Even if the fetus is an innocent person, you have not given the fetus permission to use your body. Since you have not given the fetus permission to use your body, the fetus has no right to use your body. No one has the right to use your body without your permission. Even if the fetus needs your body in order to live, the fetus has no right to use your body in order to live. No one has the right to use your body without your permission, even if that person needs the use of your body in order to live. You may refuse to allow another person to use your body, even if the other person will die as a result of this refusal. So, since the fetus has no right to use your body, you may refuse to allow the fetus to use your body, even if the fetus will die as a result of this refusal. However, the only way for you to refuse to allow a fetus to use your body is to have an abortion. Since you may refuse to allow the fetus to use your body, even if the fetus will die, it follows that you can refuse to allow a fetus to use your body, even if this involves having an abortion. Hence, abortion is permissible in the case of pregnancy as a result of rape. Now, of course, it is allowed by this that you may allow the fetus to use your body, but since the fetus has no right to use your body, unless you give it permission, if you do allow the fetus to use your body, then this is a supererogatory act on your part, and not anything that is owed to the fetus. If you allow the fetus to use your body, then you're being a good Samaritan. As Thompson points out, in 1971, Good Samaritanism was not required by any other U.S. laws, except those laws that prohibited abortion, even in the case of rape. And that's the first quotation on my handout, is it? Is there a handout in front of people? Yes, okay. So quotation 1. My main concern here is not the state of the law in respect to abortion, but it is worth drawing attention to the fact that in none of the United States is a man compelled by law to even be a minimally decent Samaritan to any person. By contrast, in most states in this country, women are compelled by law to not be merely minimally decent Samaritans, but good Samaritans to the unborn persons inside them. It does show that there is a gross injustice in the existing state of the law. Right, so that's 1971, 2 years before Roe. Now, I want to make two amendments to Thompson's argument. I take these to be friendly amendments that Thompson would essentially agree to in this paper. I am, however, along the way going to point out one inconsistency that drives the need for the Second Amendment. Okay, there are many objections to Thompson's argument. The most forceful objection, I take it, is that although I may refuse to allow another person to use my body, even if this refusal results in that person's death, I am not allowed to kill another person if this is the only way to refuse another person the use of my body. However, I admit to finding this objection wholly unconvincing, and so does Thompson and Thompson's interpreters. If someone else wishes to use my body, and I refuse to allow this person to use my body, then it does seem that I may indeed kill this person if that is the only way to stop this person from using my body. To quickly do what philosophers do and imagine a scenario, right? If somebody's kidnapping you and they're going to hold you in a basement for 9 months, and the only way to, and they'll let you out after that, right? And the only way to stop them from holding you in a basement for 9 months is to kill them. There's literally no other way before they close the door and shut you there for 9 months. Then you're morally permitted to kill that person. It's the only way to stop them from keeping you there for 9 months. So the fact that you could kill them as opposed to merely let them die doesn't seem to make for a difference here. It seems the permission extends to the killing as well. So I don't think that that objection is one that succeeds. Now, there is one possible way to argue that what I just gave as an example fails to be sufficiently analogous, and that is, well, there's some person intent upon kidnapping you, right? Some person who's got an ill will towards you, and that's not true of a fetus in any context. A fetus doesn't have intentions towards you. Therefore, even if it would be the case that you could kill your kidnapper, you couldn't kill the fetus. But in this respect, I think Thompson's argument needs to be amended. It's the first amendment I want to make. It is not completely true that the fetus in the case of rape is innocent. Or at least, it is not true that the fetus is not already engaged in a rights violation. Even if the fetus is innocent of any intentional wrongdoing, it's still true that the fetus is currently using someone else's body without her permission. Hence, according to Thompson, the fetus is currently violating someone else's right. Hence, the fetus is engaged in a rights violation, albeit unintentionally. Now, at one point in her article, Thompson does provide the following analogy, which I think supports what I just said as an interpretation of her position, even though it's a slight amendment to what she says. Quotation 2 on the handout is a case in which she imagines you are essentially trying to protect yourself against pregnancy, but nevertheless you become pregnant through a failure in contraception, etc. So I'll read out quotation 2. It would still be more absurd to say this if I had bars installed outside my windows precisely to avoid burglars getting in, and a burglar got in only because of a defect in the bars. It remains equally absurd if we imagine that it is not a burglar who climbs in, but an innocent person who blunders or falls in. Now, I want to take that innocent person who blunders or falls in. I take it that you couldn't understand that as an innocent trespasser. But then if you have an innocent trespasser, they're not failing to engage in a rights violation because they're engaged in a trespass. So that's the way I would like to understand the case of the fetus in the context of a non-consenting pregnancy, a pregnancy as a result of rape. Now, the name that I will give to that is innocent burden, because I want to preserve the non-maleficent in the lack of intent, and yet I want to preserve the idea that there's already a rights violation in being a burden. So in the case of pregnancy as a result of rape, the fetus is, quote, an innocent burden. The second amendment I would like to make to Thompson's argument stems from what I take to be a possible, or at least possible inconsistency in the argument. She's concerned in the paper to argue that an act of good Samaritanism, it is an act of good Samaritanism to go through with a 9-month pregnancy. It's not at all even selfish to refuse to go through with a 9-month pregnancy in the case of rape. However, she thinks it would be an act of minimally decent Samaritanism to go through a pregnancy in the case of rape if pregnancy only lasted 1 hour. That is, she thinks that it would be selfish to not go through a pregnancy as a result of rape if pregnancy was only 1 hour long. So, turn to quotation 3. Suppose pregnancy lasted only 1 hour and constituted no threat to life or health, and suppose that a woman becomes pregnant as a result of rape. Admittedly, she did not voluntarily do anything to bring about the existence of a child. Admittedly, she did nothing at all which would give the unborn person a right to the use of her body. All the same, it might well be said that she ought to allow it to remain for that hour, that it would be indecent in her to refuse. Now, although the fetus would not acquire a right to the use of one's body if pregnancy was only 1 hour long, and hence, although one would still be within one's rights to refuse to allow the fetus the use of one's body, even if pregnancy lasted for only 1 hour, she said you would still be greedy, stingy, or callous if you refused to go through a pregnancy in the case of rape, should it last only 1 hour. One would not be acting unjustly. There's no rights violation, but one would be stingy or greedy or callous. Now, she doesn't give enough of an argument for why one is being stingy or greedy or callous in refusing to go through a pregnancy for only 1 hour in the case of pregnancy due to rape, and I'm not going to defend that claim. I think she has more to do. But what's interesting about that claim is that there's this other passage in which she says something that seems to be much stronger, and that's quotation 6. Quotation 4. Okay. While I do argue that abortion is not impermissible, I do not argue that it is always permissible. there may well be cases in which carrying the child to term requires only minimally decent Samaritanism of the mother, and that this is a standard we must not fall below. Now that's tough for a philosopher to read. In fact, it seems like an outright confusion. To say that an action is impermissible is normally understood to mean that it's wrong, that it's unjust. It's more than saying it's greedy or selfish. Stealing or kidnapping is impermissible, right? It's wrong. It's unjust. You wouldn't just say it's greedy or selfish to kidnap people. If that's accepted, then she can't consistently say that in cases in which carrying the fetus to term requires only minimally decent Samaritanism, so those are the cases in which it would be, as it were, only merely selfish, are cases in which having an abortion would be impermissible. She can't say that there are impermissible abortions in those cases. Rather, she must say that in such cases, having an abortion would be permissible, but would be, her language, indecent, callous, selfish. So the language seems much stronger if you read impermissible and permissible the way that we normally would, right? It's much stronger than what it suggests here. So the language should be toned down or changed. Those words should be changed. Okay, now I want to come to the most puzzling claim in the entire paper, which comes at the very end. And this is number 5 on the handout. In other cases, resort to abortion is even positively indecent. It would be indecent in the woman to request an abortion and indecent in a doctor to perform it if she is in her 7th month and wants the abortion just to avoid the nuisance of postponing a trip abroad. Now, I'm worried about this claim in the paper. We've already seen reason to change the language above from impermissible and permissible to something like selfish versus unselfish, or selfish versus generous. But now we've got a claim that seems to be pretty strong, which is in the case of a 7th month pregnant, in the case of being pregnant in the 7th month, it would be indecent to go ahead with having an abortion. Here's the problem. What's the status of the pregnancy? Was it a pregnancy as a result of a rape or not? So let's go back to the argument. This is quotation 6, the key cornerstone of this argument. 6. I suppose that we may take as a datum in the case of pregnancy due to rape, the mother has not given the unborn person a right to the use of her body for food or shelter. Surely we do not have any special responsibility for a person unless we have assumed it explicitly or implicitly. Okay, so now we have a choice. We can say in the 7th month of pregnancy there are 2 possible supports or arguments for why she would have the argument here. If it's the case that in the 7th month of pregnancy this means that you have given permission for the fetus to use your body, then it seems like she's actually got to claim here that it would be unjust. It would be impermissible. You've given the permission to use your body. 7 months later, then the fetus has a right to the use of your body, and so the abortion will be wrong. Okay, but let's change it to the other possible argument, which is that you didn't give it permission. So you're pregnant as a result of rape, and you've been kept in some situation where you can't avail of any abortion for 6 or 7 months, and you're in your 7th month. Now is it the case that it becomes that you can't go through with an abortion because it will be indecent with 2 months left? I don't see how. So I think this is a failure in this part of this argument to show how it must be either what she says indecent. It seems that it must either be unjust or not indecent. And that's the second argument I want to make, second amendment I want to make to the argument. The conclusion that should be reached, given what she has said, is that all abortions in the case of rape are permissible. And that's because those are cases in which no permission has been given to a fetus to use the body. And that's irrelevant as the fetus moral status. The fetus can be a person possessed of any number of rights normally, but they don't possess that right, because that right is only one that's given by the woman. Thank you.
I think the obvious question maybe others have is, what about cases not of rape?
if it's the case that everybody can agree with the first part of the argument, that it's always permissible in the case of rape, then an enormous amount has already been done. That's a hard point. So if it's the case that everybody agrees with that, then the further argument is going to be as follows. Is it the case that you can say that a person has consented to certain things that they may foresee as a result of their voluntary actions or not? And the debate continues with that. But there are at least enough philosophers who argue that knowing certain things can occur as a result of my voluntary actions does not thereby mean that I have granted permission for another person to use my body. But I haven't tried to defend that because even defending this much here today is difficult enough. A subtitle for this paper, given the other paper that was mentioned earlier in the day, so the subtitle of this paper is The Relevance of Rape.
I want to take the last point you made, especially in light of quote 9 on the handout that you provided us.
Oh, the one I didn't get to read, yeah.
Because I think that the frozen embryo cases present us with a very interesting question. Is the right to abortion the right to kill, or is it the right to be free of pregnancy? And so it seems to me, if you take the position that a woman, you suggested that there was some sort of coercion that did not allow her to avail herself to the abortion until the 7th month. But if a woman freely delays to the point where the child is viable, it seems to me, given especially the point she makes at the bottom, that there is a difference. She can free herself of the pregnancy by giving birth and need not kill the child. Would you agree with that?
Yeah. So here's what Thompson says about the following. He thinks that viability makes for a moral distinction because at the point of viability it is possible to refuse the fetus permission without having to have the abortion. And so she argues that in cases in which you could transfer a fetus from one to another or to some incubator or something whereby it was an artificial womb case, if you could do that and if the procedure was sufficiently non-invasive, then she thinks that you are actually required to do that. So that would be to assume that the procedures for doing that will be sufficiently non-invasive to your body that it would be for her as easy or as simple as she would put it, disconnecting from me and connecting to you, something like that. If that were what were involved in not being pregnant any longer as a result of being pregnant as a result of rape, if that were what was involved in transferring the pregnancy in some sense, then she would have the view that abortion is not permitted there, yes. But there is one thing that she doesn't emphasize enough that I didn't get to in the final quotation, which is there's one disanalogy that's normally made between cases in which you switch from being the person who's providing bodily assistance and the case in which you say adopt other children. That is, it is a matter of being bodily invasive. So the question about whether one could do the transfer of pregnancy would come down to how sufficiently invasive bodily that transfer was.
Every case in the United States at the appellate level has ultimately determined that where there is a competing claims to implantation of a frozen embryo, that the person who chooses destruction or non-implantation prevails. Every single case. Which to me really does posit that question.
Okay, so let's quickly say she assumed for the sake of the argument that the fetus is a person. She doesn't believe that for a moment. She would say about fertilized eggs, they're not persons if you ask her that separately. The argument was grant the premise that they're persons, you can still have an abortion in this case. So if you don't grant the premise, as she wouldn't in that case with that argument, she would say there are other reasons for why you can destroy fertilized eggs that aren't persons. That's what she would say. But that's not the paper.
May I say something first about the last point that Professor Collette made? You know, Lynne Kohm has done some very interesting work on the right not to procreate. So, you know, there is another disanalogy, which is you have two parties interested in that embryo, and one vehemently, as in Davis v. Davis, does not want to bring a life into being that they are not going to, they don't intend to have a connection to. So it's actually like a veto power more than it is about the status of, I think it's a veto power between two adults more than it is about the status of the thing. And I can understand why that would be troubling, but I just think there's another way to understand that line of cases.
Fair enough, but I think the other way to understand it is
So just as to the first, the question is what constitutes being a parent. So her argument is that if you're pregnant as a result of rape, you haven't agreed to pregnancy, therefore you haven't agreed to being a parent in any sense of a role. So a biological fact of being pregnant does not a parent make for her. And I take it that that's a pretty straightforward factual normative distinction that is defensible. So she holds the position that you're a parent by voluntarily assuming the role of parent, not by being pregnant as a result of a non-consensual sex act. So you are considered biologically a parent insofar as you're pregnant, but you're not considered for the purposes of having obligations stemming from a role of being a parent, to be a parent in her example. So she explicitly says, whether you agree with this or not, she explicitly says that you have to have assumed it explicitly or implicitly in the case of having the special responsibility. So that's what she says to that. This would be to say that with respect to people with whom one has assumed no role, one has no responsibilities for them of this kind. With respect to roles, one has assumed lifeguards, fire persons, etc. Yes. Now, with respect to the second matter of trespass, I've given that. I'm wary of going too far with this because she's given it kind of as an example. I've taken it from that, but I take it the argument is still going to be the following. There's a difference between insisting upon the following. Somebody needs my help, and I can give it to them or not, versus somebody is already using my body, and I can allow them to continue use of my body or not. So I think that actually trespass is too weak, because this is bodily invasive without my consent. And so I think if trespass is too weak, we go for something stronger. I said bodily burden in the end.
Can I follow up on that, actually? Can I follow up on that question? With the parent-child relationship, obviously there are generally special duties of parents to care for their children. Parents can be charged with crime if they neglect their child. But I don't think it goes so far as parents being required to give up their bodily integrity even for the sake of their children. And there have been some lawsuits about this, I believe, where family members are seeking, say, bone marrow. So just hypothetically, say it's an estranged father, someone who never knew his child. The father and the child are a bone marrow match. Could the child force the father? Could the state arrest the father, clamp him down in a hospital, take his bone marrow, which is a replenishable resource, right? I could give my bone marrow and be just fine, although it's a painful procedure. Could the state do that to a father? I don't think so.
I think they did in Brotherton. I think
Forced
they did.
a father?
No, I think
They
there was
do with
a
child support.
forcible kidney transplant from a mentally disabled child to a brother who was. So there's a pair of cases, Brotherton and Strong v. Strong. Right, Strong v. Strong. I don't know about Little, but yeah, so
But weren't the
Massey
parents,
is all
but that
over
was
the
about
bioethics.
the parents were consenting. The parents were giving substituted consent.
No, and not in Brotherton. Brotherton, I want to say they forced him, and it was challenged as a due process violation, and they didn't win. I'll have to go back and look. But there's a set of cases that split just on this.
Right, but I would think it would have been substituted consent of the parent for the brother. I mean, I can't imagine an adult who's refusing to donate bone marrow could then be forced to donate that bone marrow. Or another example, could you force parents to say, once you're dead, you have to donate, or say it's a dying father, the child needs the organ, once you're dead, in this country you still have control over your bodily integrity after you're dead. There's no forced organ donation.
There is in Texas. They can take your visceral organs in Texas. And we have presumed consent laws in all 50 states for your corneas, which are distinguishable. But so even that, I think, falls apart.
But I guess that raises the question, when do we do this? Why do we do this? And are we treating women differently in making women give up their bodily integrity for their children? And that raises equal protection concerns. We've been focused on due process, obviously, because we're talking about Roe versus Wade, but many feminist scholars have said actually the abortion right would be better grounded in our equal protection jurisprudence. Rita Siegel's written extensively about this, and we'd have to look at these comparators and say, in what other situations do we make someone give up their bodily integrity to preserve another life? And if we're doing that only in the pregnancy situation, or is it because of gender stereotypes? Is it because of assumptions about women's appropriate role as mothers? And that is what our equal protection jurisprudence protects against, which is women being forced to conform to gender stereotypes.
I was just going to quickly add that we do this with child support, with the presumed parenthood argument.
That's
It
money,
doesn't-
not bodily intent.
Right. I'm kind of separating myself from the autonomy argument, but back to the presumed parenthood argument. Child support cases against dads that did not want to be parents and wanted the abortion to happen all say the husband assumed, or the father assumed parenthood at intercourse. And those are without exceptions, even though men have made lots of equal protection arguments, not based on autonomy, which is probably why they lose. But child support is where that presumed parenthood is definite. Thank you.
So James, if I'm only a parent if I consent,
According to Thomas.
argument that applies for men as well, and does it apply after birth?
Insofar as I can elicit this from her article, yes. So she does give, I think there's quotation 7 actually. If a set of, this is handy, okay. If a set of parents do not try to prevent pregnancy, do not obtain an abortion, and then at the time of birth the child do not put out for adoption, but rather take it home with them, then they have assumed responsibility for it, they have given it rights, and they cannot now withdraw support from it at the cost of its life, because they now find it difficult to go on providing for it. So if I'm taking that to be a statement of I have, the question is it only not explicit because I haven't said this? But yeah, I take it there she claims that you have assumed the role of being a parent, you've assumed the role of taking the child in, and that means that the child has a claim right against you. Yeah? So it's a voluntary act on your part such that there's now a claim right against you, but it had to be a voluntary act for the claim right to exist against you for that sustenance. Now, the part that I think is disanalogous with that paragraph is that this is not about the use of my body. So it's not clear to me if it was the case that I was a parent who took on a child, but that child remained attached to me bodily, and I at some point later on decided that I didn't wish to go through it continuing to be a parent. It's not clear if her argument makes it the case that I must now continue to allow the use of my body by that other person. So I take it that in the case where it's a matter of use of my body, that's inalienable. I don't know if she actually says that here, but I take that it's inalienable. So I can always revoke the use of my body by somebody else.
But not your financial obligation.
Yeah, I've made no claims about so-called deadbeat dads, etc., etc. Nothing said that about here. You know.
Just on that, I mean, Lynne Marie's point is well taken, whatever the grounding of it. It is almost impossible to have paternity disestablishment in the United States, and these cases are not coherent. You know, but basically you live with somebody, whether you know them to be pregnant by someone else or not, and that marriage or relationship lasts for a number of years and you provide financial support. At the back end, it is soak the rich, right? You have money, and as between the state having to pay for this child and you paying for it, you can almost be assured you are going to pay for that child. And they go about it in different ways, parent by estoppel, or, you know, you create a relationship in loco parentis, or some other way, but they are going to soak the rich, right? And this is a place where Clark is exactly right. This person may well not have consented to that, and it may not be because of marital presumptions either. It's just the fact that they have money.
But it's money, not bodily intent.
No, I
That
do
is
agree
very
with that,
important
but
distinction.
yeah.
Ms. Mann, I was wondering about the implications of her argument for like the draft. I mean, we don't have that now, but there have been periods in history where people have been drafted into the military without their consent and forced to go put their body at risk. Would the argument have implications there?
Good. Two questions. One is, to what extent you haven't consented. If you, I mean, I say this sometimes gingerly because I'm not a citizen of the US. So, what does it mean to say that you consent to remain, you know, a citizen within the US and don't leave when you know there's a possibility of a draft, right? So it seems like if you use, you know, Crito-type arguments in Plato, you may have consented. The question is whether you've consented to fight in a war that you hold to be unjust. But actually that's not true, because they've often given exemptions for conscientious objection to fighting in wars that you are opposed to on moral and religious grounds. So it's not like an absolute requirement to fight, but it's a requirement to fight in a war which you can't find an unjust reason for not fighting it. So, yeah, you still have to serve. Right, but his point is about putting myself in bodily danger because. So I take it that you may have actually consented to put yourself in bodily danger in a war which you can't determine to be unjust by remaining within the U.S. If you don't like that, come to Ireland. We have lots of problems, but no draft. And become a citizen. But what's interesting about that, even to make the point that you are putting yourself in a position of danger with respect to your body, there cannot be, I mean, I've argued this in other contexts, there cannot literally be a requirement of the draft that you die. That can't actually be the draft. Hobbes makes the point that if it's the case that you are in a situation with a contract whereby it requires your debt to fulfill the contract, that contract is invalid. And I take it that that's morally true, and even, I want to say, although I'd be gingerly here saying this, that should be legally true as well. The draft to go fight is not the draft to die. And that would be enough of a reason to distinguish it here. But you might say, look, am I not obliged to intentionally put myself in the situation of having somebody else dependent upon my body for 9 months by being drafted? I don't even think that's true. I don't think that a soldier is required by the draft to provide his body to another soldier for 9 months.
Yeah. Hi, this is for Robin and Mahon. I'm a little confused by your presentation because the American College of OBGYN, the American Society for Emergency Contraception, American Society for Reproductive Medicine, I could go on, other contraceptive researchers have indicated that Ella works by preventing ovulation, and that it works, I think, for a long, I'm not an expert in this area at all.
120 hours. Yeah, works
Works for a longer period of time, and because it operates also during the LA surge.
That's exactly
the
right.
surge prior to the ovulation, but that it's still acting to prevent ovulation, and I think the science is pretty well settled. So why should I believe you guys who are not scientists?
No, we're not asking you to believe us.
Yeah.
The answer is that you saw 2 peer-reviewed journals, and there are others that suggest that, in fact, there was grounds for the FDA label. The man that you saw, Charles Lockwood, who was on the panel
Yeah, I've cross-examined Charlie Lockwood and all of that.
The point that I'm making is, look, the FDA does not lightly put these disclosures on these labels. In '99, when they did that, there was evidence to believe that there might be a contragestive effect, which is a post-fertilization effect.
Right.
And now there is not, and it probably should come off that label, and there should be no duty for physicians to discuss that as to Plan B with a patient because there's no legitimate scientific basis for believing that. But at this point,
You're saying that's true with Plan B,
Yes,
but
ma'am.
not with Ella?
Yeah, and that's where we landed. But with Ella, which was approved in 2010, we do not yet have that kind of empirical grounding to understand precisely when it works. People like Mayek and Jeffrey Keenan are saying that if a woman takes it sufficiently late in the time after having unprotected sex and fertilization has already occurred, and they're saying that if it's within 5 days before ovulation or within 24 hours after, and it's taken sufficiently late, the only way you can explain its increased effectiveness is as a contragestive, i.e. post-fertilization effect. Now, that would not be an abortifacient under the government's definition of an abortifacient since 1975, but it would be an abortifacient in the minds of many women, as you saw from these studies. And there are other studies in Europe and Mexico, studies of OBGYNs talking to their patients in California, studies in the southeast of the United States, where women all say, not all of them, but many big chunks of women saying, it would bother me greatly to use a drug that I understood to work after fertilization.
Okay, but you would agree that if it is true that Ella prevents ovulation, then people's definition of abortion, whether it's ovulation, or definition of pregnancy, whether it's ovulation or implantation, would be irrelevant.
Yeah, and we said that about Plan B, but you have to understand that we're talking about a pool of possibilities. And the wide, vast majority of them, the people who are using Ella, are probably using it as questions, and they may not, in fact, know whether they have actually already released the egg by the time that they've taken this drug, or whether fertilization has already occurred by the time they've taken this drug. It really is a set of possibilities when a woman takes it sufficiently late. And that's the problem with the 120 hours.
And it was determined to only act as a contraception.
And there's 14 years of experience with Plan B, and the label says 72 hours. We're talking about a label that allows people or suggests to people that they can take it much later. And that is just frankly a gamble that fertilization has not already occurred.
Yeah, we're supposed to give one right now.
Yeah.
But, yeah, we are. Sort of.
I know.
Sort of.
It's okay.
Hello? Excuse me, we just want to give a couple quick closing remarks. But by all means, if you're on the undergrad side and need to go or go to class, go, please. We don't want to keep any of you. It is Friday afternoon.
Is this even on?
Well, I don't know. Maybe this won't work. I think this is off.
Yeah.
But I know.
I know.
I need a gavel. Michael, Fennel. But, Fennel, can you tap Teresa Collette? So just wanted to say a couple quick closing remarks. This will be fast, we promise. Good afternoon. I just want to introduce Laura Goss, our symposium editor, who hopefully everyone has had a chance to meet at this point watching the Law Review. I'm Thomas Short. I'm the editor-in-chief of the Law Review. And basically, on behalf of the Law Review, we'd just like to thank everyone for making this event such a great success. I think a lot of the credit goes to the panelists for the insightful presentations. They were all fantastic. To the moderators for facilitating the questions and discussions among the panelists and with the audience. Really appreciate all of that. Our sponsors have been fantastic. Without their efforts, none of this would have been possible. Once again, ACLU of Virginia, Francis Lewis Law Center, University of Faculty for Life, Virginia Now, and the Provost Office of the Washington University. And finally, these four people, most importantly, none of this would have been possible. One is Dean Calhoun, not to reiterate what I said last night, but really his efforts have been phenomenal. He did come to us with this idea and was pushing balance, and we were really, the Law Review was very much in support of it, especially the balance perspective. But when we went into this, we were sort of thinking that it would sort of be Dean Calhoun pushing one side of the balance and us pushing the other side of the balance, and that was completely wrong. Absolutely wrong. We were proved wrong on that. It was all of us working together, fighting for the balance. And that was a phenomenal experience. I'm happy that it worked out that way. And it was, I just think, a brilliant, I think we all worked very well together. I'm very happy that it came together the way that it did. So a lot of credit to Dean Calhoun for that. Thank you so much. I think we can all look in the mirror after all this. I had a professor say this to me one year and said basically at the end of studying for exams, you want to be able to look in the mirror to yourself and say you did everything you possibly could. And I think the three of us did everything we possibly could to make this as balanced as we could, and I think it was a success. The following three people, it's hard to distinguish how any of them could have done anything differently or participated, but they are incredible. Basically, Laura Goss, a symposium editor, who did a phenomenal job with everything, all the details. And then Wendy Rice, who's in the back, who also helped with all the logistics. And none of this would have been possible without Wendy Rice. I'm going to give this to you after this is over, if that's okay. To give you an idea of how critical Wendy is, she is actually engaged with organizing two events simultaneously, one of which was also happening last night and has sort of finished. And so we were sort of sharing her. And I was basically begging her all day to get her to come to this because she has so much going on and she's so engaged and we all rely on her so desperately. So thank you so much, Wendy, for all of your help. Honestly, none of this could have happened without you. And of course, finally, Lisa Gerhardt, who's the Law Review's administrative assistant, who just helps us invaluably throughout everything that we do. Thank you so much for all of your help as well, Lisa.
And to interrupt real quick, there is one guy that we all want to thank, and I personally need to thank. This is a guy who spent just as much time, if not more, on the symposium than I did. And without his help, this really would not have been possible, and I most likely would have gone crazy. Please join me in thanking the best editor-in-chief of any law review around, Mr. Thomas Short.
And also, finally, the staff of the Washington Law Review have helped us ferry panelists around and pick people up from the airport and take people to the airport. They've just been very, very invaluable as well, and will help edit everyone's articles, which we are eagerly looking forward to, and anticipate emailing lots with all of you once again on another step of the process. So thank you all again for everything. It's been a great couple of days. Thank you.